So the question about professional responsibility and legal financing really breaks down into thinking about legal financing from its two major components. And those two major components are the financing can either be client-directed or it can be lawyer-directed. And for purposes of this short presentation, I'm going to stress the ethics for lawyers relating to client-directed funding. Client-directed funding is when a lawyer's client chooses to sell a contingent interest in their recovery to a funder, to a capital provider. So this is really a transaction between a layperson who's the client and another layperson who is the funder. And so with client-directed funding, the lawyer's role is really to stand on the side and in addition to his or her advice to the client on the underlying case in chief, to make sure that the client understands additional risks and benefits for the client pursuing this side deal with a funder. And that means that basically the ethical issues that are raised when a lawyer has a client who seeks financing aren't that much different than when a lawyer has a client who's seeking any other financial deal that might have risks and benefits. However, there are certain obligations that attach to that lawyer that come with the additional responsibility of advising their client. First of all, the lawyer can choose not to add to the scope of representation any additional obligations. So the lawyer can say to the client, I'm not going to help you draft this additional contract, or I'm not going to give you advice about its advisability. Now, the client, of course, can respond, and the client has, in fact, an obligation to demand competent representation to the extent that it attaches to the underlying case that the lawyer is working on. So, for example, the client has every reason to expect that the lawyer recognize that there could be certain risks to the underlying case for the case in communications with the funder. So the lawyer has to make sure that the client understands that any communications between the lawyer and the funder authorized by the client could, for example, potentially affect the waiver of attorney-client privilege. These are things which a competent attorney has to advise the client about. Now, that doesn't mean that the lawyer gets to take control and tell the client what to do. It just means that the attorney has to give the client choices, and those choices have to be based on competent advice. And in this, there's nothing especially unusual about the lawyer's ethical obligations or professional responsibility obligations when a client says, I want to get funding. But it does mean that a lawyer has to be aware that there can be additional challenges and problems which the lawyer has to be competent to advise the client about so that the client can make informed choices. Confidentiality is one. Waiver of attorney-client privilege is another. Potentially, there are also concerns regarding underlying state law of champerty or maintenance that could affect the enforceability of the contract which the client wants to make with the funder. The lawyer should advise the client about that. Again, the lawyer could advise the client that they're not really capable of giving that advice and that they should seek advice from a more well-qualified attorney. The lawyer has to be aware of his or her own limitations. So in that sense, really, the ethical obligations of an attorney when it comes to client-directed funding are more of the same of what lawyers face every day when clients are trying to engage in complex and not so complex financial transactions with other parties. Now that's the first kind of issue with regard to client-directed funding. I want to briefly talk about lawyer-directed funding for a moment, because lawyer-directed funding is an entirely different matter. The ethical concerns that arise with lawyer-directed funding come from the fact that lawyer-directed funding is a funding relationship between a capital provider and an attorney. It's not a funding relationship between a capital provider and the attorney's client. It's not client-directed funding. It's directed towards the lawyer. Now, many, many open questions remain today about lawyer-directed funding. I will be frank and say that I personally think that most of the open questions about lawyer-directed funding are misguided. I have publicly stated that I think that lawyer-directed funding is both ethical and also desirable, but others have disagreed with me, including some ethics committees in various states. However, it should be clear that with lawyer-directed funding, the issue that arises is whether or not a lawyer taking capital from a capital provider who pledges a contingent interest in the outcome of a matter, fees that they will earn from a matter, whether it be an hourly matter or a contingent recovery, may be violating what's known as Rule 5.4a in the model rules, and in other jurisdictions such as Texas or under other designations such as 5.04. But in any event, the prohibition on fee splitting is a concern in the area of lawyer-directed funding. Now, in my opinion, there should be no concern because the whole purpose of Rule 5.4, the prohibition on fee splitting, is to preserve the professional independence of the attorney, and there is really no reason to believe as a matter of logic or as a matter of empirical evidence that there is any greater interference with professional independence when a lawyer takes out a conventional recourse loan secured by the assets of the partnership or their own personal assets, and when a lawyer engages in lawyer-directed funding in which they pledge a contingent interest in the outcome of fees from a matter. That is a fundamental view on my part about the reason why Rule 5.4, the prohibition against fee splitting, does not prohibit lawyer-directed funding, because professional independence is not necessarily compromised. But to the extent that an attorney does in any way place their professional independence at risk, then of course, for reasons that are really general reasons, not having to do specifically with lawyer-directed funding, ethical implications are triggered, and the attorney should in fact not only not put their professional independence at stake, but they should in fact be aware that under all circumstances, including both Rule 5.4 but also Rule 1.7 relating to conflicts of interest, that they may never, ever engage in a financial relationship which compromises their professional independence and which places them in a material conflict of interest with their client. To conclude, client-directed funding is a very familiar form of activity in the sense that it's merely a matter of a lawyer advising their client about how to deal fairly and competently with a third party in a financial relationship. And the ethical problems that arise from that are ones of really competency, scope, and being aware of what your client's doing to give them your candid and frank advice. Lawyer-directed funding is a more controversial issue. I believe it's going to be seen eventually by ethics committees and by stakeholders in the legal profession as nothing other than another way of raising capital for lawyers like conventional recourse lending. But it does raise potentially issues specific to the rules of professional responsibility, such as the questions of Rule 5.4's professional independence, that need to be addressed carefully. However, with lawyer-directed funding, like client-directed funding, the bottom line is it's a practice which is designed to help clients maximize the resources available to pursue the ends of their representation with their attorney. And to the extent that in either of these types of funding, the attorney can assist their client to achieve their ends of the representation, they are ethical and beneficial practices which a lawyer should be able to assist their client in securing to the extent that they help the client secure his or her ends in the representation. Thank you.